Hello, I'm Jeff Weintraub. I'm a management side labor attorney, labor and employment with Fisher Phillips. Fisher Phillips is a nationwide labor and employment firm. All we do is employment law and labor law, and strictly on the management side, the company side. So we're the good guys, or the bad guys, depending on your viewpoint. Um, and Fish Phillips, as I said, does the same thing I do, multiplied by, I think we have 580 attorneys now, all doing labor and employment in maybe 38, 39 states and Mexico. So I've had a great relationship with this firm over the years, and I'm glad to be with you all today. I've also worked with NBI on a lot of projects over the years, and this is something a little bit new. I think it's a podcast, so that'll be great. Okay, so what we're going to talk about here today is the new Federal Trade Commission rule. Wow, which, in case you don't know, was just announced a couple days ago. It's going to be published on May 7, which we're recording this on May 6, so that will be tomorrow. I'm not sure when you will see it. It will have already happened, I'm sure. So uh, it's a new day, or it's not, depending on how you look at it, because this thing's going to get challenged. But the courts are unpredictable, so we don't know exactly what's going to happen here. So, what we're talking about, of course, is non compete agreements, and we'll also be touching on non solicitation agreements, repayment of training cost provisions, so forth. No rating provisions, sometimes called no pirating and called other things, no recruiting, and so forth. Anyway, we'll talk a little bit about that, but primarily today about non compete. So, what happened on April 23, a couple of weeks ago? um, FTC finalized its new rule, the one that's going into effect on May 7, will have gone into effect on May 7 when you see this. And it bans almost all new and existing non competes. So, from publishing, it will take effect, it's scheduled to take effect 120 days after being published in the Federal Register. So, that by my calendar, I think I looked this morning, it looks like it would be late August, early September of this year, something like that, that it is scheduled to be implemented. So, under any scenario, you have 120 days to do whatever you need to do to get ready for this or to make any changes or whatever you're going to do. So, it's good that we have a little time in there. And yes, I do agree with some of you are thinking now, oh, this will never go into effect. The courts are going to stop it. I don't know. I don't know how that's going to work out. I tend to believe that some of it is going to survive, perhaps all of it. So we'll just wait and see. The real question in my mind is whether how much delay there's going to be if there's court action, and that's just unpredictable. I don't know. Nobody knows. So a little background on the FTC and the non-competes. FTC, as I'm sure some of you are aware, have been um, getting upset at employers using non-competes for many years. The FTC says they hurt employees and they hurt the economy and they're anti-competitive and so forth. Um, they are, of course, somewhat anti-competitive. That's the very essence of what they are, is they're intended to stop not all competing, but competing where there's been an unfair advantage. So we'll cover a little bit of that. So employers say that generally that they need the non-competition agreements to protect their trade secrets, their confidential information and processes, to protect the company from others, third parties, competitors who may come in and poach their talented employees that they've trained for years and have provided all kinds of information that, if passed on to a third party, would give that third party an unfair advantage. And if you just think about this a little bit, just to give you where most of us come from on this issue, um, let's say you've got an individual who comes to work for you, and in their mind they have the sole intent of working for you for 6 months to get the names of your customers, and sometimes even more important, your customer preferences. If you're a suit manufacturer or a suit salesperson, Perhaps they want to know your big buyers around town, and that they all like plaid jackets of a certain style, and they like them extra long. So you have that information. You've got an advantage. And guess what? You didn't have to work years and years and years like you, the employer, had to do to get all this information. You get it free. Boom, wham, you got it. Um, the drink company worked for years to see how much carbonation would result from a certain chemical formula. And they spent hundreds of thousands of dollars on that process in the lab. And then somebody leaves, takes it with them, and the competitor gets it for free. In other words, they can now compete against you without having to spend those hundreds of thousands of dollars. And that, my friends, is an unfair advantage. Now, they're not all straightforward and simple like that. I get that. And I'm taking, some would say, well, you're taking extreme examples. Well, I don't know. Maybe they are, but, I do have them happen like this frequently. So, um, yeah. Okay. So that's the background of this a little bit. I think you're aware, most of you probably are aware that Chamber of Commerce, U.S. Chamber of Commerce, has sued FCC over this. And there's a small Texas company, I believe it's called Ryan LLC, has sued. And I just learned a couple of days ago that ATS Tree Services, a small business in Pennsylvania, has sued. So that's three lawsuits I know of. That's all I know of at the moment. There may be more pretty soon. So, what is FTC's viewpoint on all of this? They feel that non competes suppress wages, hurt competition, blocking workers from pursuing other opportunities out there. Again, it's hard to say, well, no, that's not true. It is intended to block what that departing employee would view as another opportunity out there, but it's an opportunity where he's taking something that will be an unfair advantage for him or the employer he goes to work for to use against you, to compete against you. But FTC says it's preventing employers from hiring the best available talent. Again, maybe that's true, but FTC, they're not talking about the harm here if the person does leave and take all that ability and knowledge that you paid them for years to develop for you, and it's taking them with them. So as FTC Chair Khan has said, quote, the freedom to change jobs is core to economic liberty and to a competitive, thriving economy. Okay. So what the new rule is going to prohibit and require. The new rule is going to ban non-competes for almost all employees, a few exceptions. Almost all your employees are going to be covered. Basically, all of your employees are going to be covered, including salespersons with key relationships to customers, production engineers, whatever. The new rule also bans existing non-competes that you have out there in almost all circumstances. And you're going to have to provide notice to current and former employees that their non-competes are no longer enforceable. So, three things that come to point here that you want to remember this in a simple way. One, you're not going to be able any longer to enter into non-compete clauses with your workers. Two, you're not going to be able to enforce existing non-compete agreements that you have out there unless the agreement covers certain senior executives, which we'll talk about. And then third, you have to provide explicit notice to current and former employees that their non-competes are no longer enforceable. As to the notice requirement, the FTC says that has got to be a clear and conspicuous notice that identifies the person who entered into the non-compete with the employee. Notice must be provided in digital format, which can be email or text, or on paper. Verbal, oral is not sufficient. It's okay if you want to tell them verbally about this, but you have to provide it in some type of writing or digital format. If the individual if you don't have an email address through no fault of your own, no street address or anything, you may be excused from this requirement. Also, FTC gave us some model notice language that you can take a look at if you want to. So, what does the new rule not apply to? Well, the new rule permits non-competition agreements with a person who is selling a business or an ownership interest or all of his ownership interests. I don't think it applies if it's just part of the interest. It has to be all the interest, I believe. It has to be a bona fide sale, a sale that's made in good faith, not some sort of sham transaction to get around the FTC rule. Parties should be at arm's length. There should be a reasonable opportunity for the seller and buyer to negotiate the terms of the deal, of the sale. The new rule also does not apply to agreements that protect trade secrets and that protect truly confidential information. Okay, that's the good stuff. That is the good stuff. Trade secrets are very important. Protect your trade secrets. Now, I mentioned senior executives. The rule does not bar existing non-competes for, quote, senior executives. So the rule defines senior executives as workers who own more than $151,164 a year. We'll call it a little bit more than 151,000 bucks, and who are in a policy-making position. So you can still enforce those existing non-competition agreements. As to the senior executives, I don't believe you're going to be able to make new ones, but you can enforce the existing ones. This is not going to be a big escape clause, I think, because FTC says that the qualified senior executives for this exception to the rule is only 0.75%. That's less than 1% of all employees. So it's not a real good escape clause. Fortunately, the new rule does not require you employers to formally rescind existing non-competition agreements. The FTC apparently felt that would be too great of an administrative burden on employers, and it probably would be. So what constitutes a non-competition agreement under this new rule? Well, the rule itself defines a non-compete clause to refer to a contract term that blocks an employee from working for a competing employer or from starting a competing business within a certain geographic area and period of time after the employee's employment ends. You know what they are. So what should you do now in this situation? Well, some employers are going to roll the dice and not make any changes and just, the courts are going to overturn this. And they might be right. I don't know. But if it was me, I would not want to take that chance. I would find, at the same time, you don't want to go overboard here and change the whole world for something that just might get overturned. So I'd find a middle approach, a balanced approach. My firm, Fisher Phillips, came up with a 5-point plan, a 5-step plan. So I'm going to go over that with you. I think it's very good. Number one, develop your own personalized strategy plan. Get together with your labor attorney and prepare an individual strategy plan. You got to look at the size of your business, how many non-competes you have in effect, the relative importance of particular non-compete agreements to your business. Are certain agreements more important? Your risk tolerance level. That's always the biggest issue to me in HR type situations, workplace. What is your risk tolerance? How much risk are you willing to take? Risk is a good thing. It can be a bad thing, but Fred Smith took a risk when he didn't make a very good grade on that paper in college, but then went out and started Federal Express, and today he's worth literally hundreds of dollars. That's a little joke, I can tell. Fred Smith lives in Memphis, um, so then the second thing, take stock over the next few months. Even if you have a high risk tolerance and you feel confident the rule is going to be blocked by the courts, you still might not want to do nothing. That's a double negative, but I believe it's properly used there. You don't want to do nothing between now and the effective date in early September, maybe. So over the next couple of months, you might inventory your existing restrictive covenant agreements, including those that bind former employees. Then, secondly, figure out which employees might fall into this senior executive exception. Talk to your labor counsel about that because you can still enforce those agreements, existing agreements. And third, track all of your new non-competes in your inventory that you plan to put in effect from here out. The third of the 3 of the 5 steps, begin planning your alternatives. So meet with your company leaders and figure out whether you can protect your interests with a less restrictive type of covenant. A good customer non-solicitation agreement or a good confidentiality clause could achieve your goals with less risk. And by the way, all courts in the country, even before the rule, consider non-competition provisions to be restrictions on free enterprise. So they're disfavored in courts, but they generally will be enforced in most states if they're reasonable as to territory and reasonable as to duration. Um, so a non-solicitation agreement, on the other hand, is almost universally enforceable. Pretty much almost all courts consider customers to be a protectable interest in that particular state, and so you can protect your customers. You can do that, and a lot of employers have already done this. Don't use non-competes; they just use non-solicitation agreements. Fourth step: consider your other restrictive covenants, not just the non-competes, but you've got other ones there. We just talked about non-solicitation. You've also got non-recruitment, or no rating, no pirating of other employees, non-servicing. When I talk about a non-solicitation, I always call it non-solicitation, but I really design it so that it's the individual departing is not allowed to solicit or serve your customers. Again, we're going to jump back on that a little bit. Non-disclosure provisions. Keep in mind that all these provisions I'm talking about, these other provisions, some court is going to be scrutinizing them one day, trying to figure out whether this is really a non-compete agreement in disguise. So that's what we're going to be worried about in the future. Is this really going to be determined to be a non-compete, no matter what you call it? Does it keep someone from going to another job? And it could if you make the non-solicitation or whatever too broad. If you make some of these agreements too broad, you're going to run into a problem. Um, Now, the training cost clause. I've always used these things: obligation to repay, training costs. They're great because, unlike non competes, they're not violated if the employee departs and starts competing. They're triggered by the employee competing. It's just a contract provision that says the employee, the departed employee, has to repay the agreed upon cost of the training. We'll say it's $5,000 or $10,000, and he's got to repay that. So when the attorney, when I send out my nasty lawyer cease and desist letter, and the opposing attorney calls and says, "Hey, Jeff, you can't enforce these non-competes," and then I disagree and we argue a little bit, and then I say, "But meanwhile, Fred," or whatever your name is, um, putting aside all these non-compete restrictive covenants, there is an obligation for training cost clause here. So please have your client cut my client a check for $5,000, cashier's check, please, because that is owed by his competing. And at that point, the conversation changes from angry arguing between attorneys to, Jeff, maybe we can resolve this thing. And then you get the thing settled. So, and remember, if you have a 2-year non-compete, you don't need 2 years. You just need a break when the departed employee can't use his face that you paid him to develop goodwill for your customers, and now he's trying to use that face for someone else. You just need a break in service so that you can put your own new person in that fellow's spot and develop goodwill with his face on behalf of your company. So you can always bargain down from the 2 years or whatever years you have. I mean, you can end up with a year or 16 months or 6 months even, just so there's a break in service there. And finally, the fifth step: get your trade secrets house in order. Um, Trade secrets, FTC says, yeah, they're fine. You can protect your trade secrets if they're really trade secrets. But if you make your definition of trade secrets or confidential information too broad, it's going to start looking like, well, no one would be able to go to work for a competitor if they can't talk about blank. So keep it legitimate trade secrets. Well, trade secrets, if you publish your customers' names in your advertising, then the customer names are not going to be a trade secret. You open that up to the general public. Now, customer preferences, that's usually something you want to keep quiet. So we're about at the end of our time here. Let me just say in a couple concluding remarks, I do think a balanced approach like Fisher Phillips has espoused with those 5 steps to this new threat to employers is going to be a very good approach for most folks, not just because of the FTC new rule, but also because a lot of states are legislating their own state laws in this area, especially in the healthcare law area, where a lot of states don't want doctors who would otherwise be serving rural or small town areas to not be able to work those areas. So some of them, a lot of states now outlawing that such restrictions, non-compete restrictions in the healthcare area. And then I think the last thing I want to mention is find a way, if all else fails, find some good ways to retain your good employees, your trusted employees, the ones that have your trade secrets information and your confidential information and their face that is the face of your company to its customers that you've been paying him to use and develop for goodwill for your company. Find ways to retain those attorneys. Maybe pay them more, give them some additional benefits. Be creative. All of that is cheaper than litigation. Trust me. So um, what you want to do is have that employee not want to utilize an opportunity to depart and go to some of their other employers who are paying a few bucks more. Maybe offer. Maybe you're already doing some remote work opportunities. Keep doing that. I mean, especially the young folks really like remote work. So if you can keep doing that or increase it, I mean, that's a good way to keep people from departing. Excuse me. That is real all I have on the FTC rule. If you'd like to know more, you're welcome to subscribe to our Fisher Phillips Insights publications, which come out whenever something interesting happens in the workplace legal world, including a lot on the FTC rule. So if you want to know about that, just email me at jweintraub@fisherphillips.com, JWEINTRAUB at FISHERPHILLIPS.com, and I'll send you the link to subscribe. Thank you very much, folks, for today. And Harley, you're there in the background. Thank you very much for your assistance. Y'all have a great